All right. Well, thank you for joining us today. We are here with Lance, and we are going to have our monthly CMU for Collins. And let's see, today is July 6th, 2023. And take it away.
Thanks so much, Melanie. And thanks so much, everyone, for joining us this afternoon. It's always a pleasure to do these presentations with you. For those of you who don't know me, I'm Lance Stewart with Angus and Terry, and we're pleased to join you for your education today. Quick disclaimer I have to give, this is not intended to be distributed outside of Collins. I will be sending Melanie a PDF later on so you guys can exchange it to your heart's content internally inside of Collins, but please don't send it anywhere else. The presentation itself is not intended to be legal advice. It's general informational purposes. It's a general informational summary. For any HOAs we currently represent or just need help or looking for counsel, we're happy to talk to them about their individual situations, but never take a presentation at face value as something you can apply as legal advice to any particular situation. We always got to look at the actual facts that you're dealing with. And a big concern with circulating presentations is that laws often change on a dime. It might happen when the legislature completes legislation in October, or might happen with a court ruling tomorrow. So always keep these things close to the vest and don't try to circulate them because they can cause confusion and even problems. We're here today to talk about, and we've got this very lovely picture of me here. We're here today to talk about operating rules. Before we dive in, I want to explain something generally about governing documents. There's a lot of confusion among board members, among homeowners, about what we mean when we talk about different types of governing documents, including rules. So before we dive in, I want to distinguish a couple of things. CC&Rs and bylaws are the big governing documents. They're the ones that are put in place by the builder from the beginning, and they usually, though not always, they usually can only be changed through a full-blown vote of the members. Okay, those are more or less set in stone until the members decide otherwise. Rules, or what we sometimes call policies, are things that can be put in place by the board without a vote by the members. And we're going to talk about some of the limitations on that, the nature of that authority, but that's a big distinction to understand right out of the gate. There are CC&Rs and bylaws on the one hand, and what we call rules or policies on the other hand, and the big difference is who gets to change them. What we're talking about today is the board can change operating rules or adopt operating rules. In this presentation, we'll be talking about some of the background regarding operating rules, requirements for adopting them, the approval process, some ways that homeowners can challenge those rules, some special provisions, enforcement of any rule that's put in place by the board, some common problems that come up, and when you want to get counsel involved. To start out with, we're looking at Civil Code Section 4340, which gives us sort of ground zero for how operating rules work. An operating rule is a regulation adopted by the board that applies generally to the management and operation of the development, that is the property where the HOA exists, or the conduct of the business and affairs of the HOA itself. The authority to create or adopt an operating rule is usually in the CC&Rs or the bylaws. There will be a provision somewhere in one of those saying the board has the authority to adopt certain rules from time to time. They can be modified without a membership vote, as I said up top, and then provide boards with flexibility and greater influence on how the HOA actually functions. A lot of times the CC&Rs and the bylaws give you sort of the general sense of what needs to be happening in the HOA, but not a lot of the day-to-day nitty-gritty, the nuts and bolts that sometimes you want to have to give both the homeowners and the board guidance on how things are supposed to be run. So the rules, the policies can be a good tool for providing some of those details of how things need to work. The builders sometimes provide operating rules from the beginning of the HOA. That's a little less common. Usually when we're talking about operating rules or policies, those are being put in place by the board of directors. Some common examples of rules, and I'm sure you're all familiar with at least some of these. Architectural policies, fines and enforcement, solar, electric vehicle charging stations is a big one these days, recreation areas. Pool rules came up a lot, especially during COVID, but still comes up from time to time. Clubhouse reservation and use, smoking, parking is a big one that comes up a lot. Rental, particularly in recent years, pets and animals, water intrusion or interior damage policies, surveillance cameras, move in and move out policies, and of course, election rules. These are all things that usually the CC&Rs and bylaws don't really go into the level of detail that you need so that the board knows how to oversee things and homeowners know what they can and can't do. These are all areas that one way or another, the legislature has said HOAs need to have certain types of authority, but don't have other types of authority. For a lot of these things, you need policies in place to specify for everyone's benefit how they're actually going to work on a day-to-day basis. Okay, the requirements for adopting a rule. Any rule has to be in writing. You can't have sort of board members saying informally, well, this is how we do things. It needs to be in writing for it to count as a rule and be enforceable. A big thing, and we'll talk about this more later on, is that any rule has to fall within the board's authority under both the law and the governing documents. Usually we mean the CC&Rs and the bylaws, and it can't be inconsistent with those things. Now, that seems a little redundant, but sometimes you think about it in both directions, it's easier to see what the problem might be. This is why you don't want rules that are just written by one of the board members or some random homeowner. You always want rules to, at some point in the process, be reviewed by the HOA's council, because the board can't pass any rule that doesn't fall within its authority under either the CC&Rs and bylaws or California law. It has to emerge from that authority in some fashion. It happens all the time that boards pass rules they're not actually technically authorized to pass. A board member might have a good idea that sounds really interesting in practice, but actually wanders beyond the board's authority. So you always want to take that step of having council review. Here's what the policy is, here's what the rule is, and here's the authority the board actually has under the CC&Rs and bylaws to adopt rules. And do these overlap in the right way, or is there a contradiction there? A rule has to be adopted, amended, or repealed in good faith, and it has to be reasonable. And certainly we see our share of rules or intended rules that aren't particularly reasonable. There is a very specific approval process. For a board to have a rule in place, for it to be enforceable and mean anything, it has to go through a certain process. And what the law says is that this process applies to only the things we've specified here, but as we go through this, you'll start to see that this really enshrines most of the issues that HOAs are going to be dealing with. So rules involving use of the common area or use of exclusive use common area. Use of the separate interest, which is the homeowner's individual property, their condo, their lot, their residence. Member discipline, fines, penalties for violating the governing documents, delinquent assessment payment plans, internal dispute resolution or alternative dispute resolution, rules for reviewing or approving proposed physical changes to the homeowner's property or the common area, which is usually what we mean by the architectural review process. Or elections. So the approval process for adopting rules that I'm about to go through is meant to apply to any rule or policy that falls into any of these categories. But like I say, most of the issues you're going to see on a regular basis with your accounts, anytime an HOA is trying to adopt a policy, more often than not, it's going to fall under one of these categories. So the approval process we're about to go through is usually going to apply to just about any rule or policy the board is considering adopting. Okay, so this is the actual approval process. Civil Code Section 4360 applies to the adoption of any new rules or changes to or repeal of existing rules for the HOA. The big one is that there has to be notice sent out to the members for at least 28 days that the board is considering adopting a policy. And there are two big components to that being sent out. There has to be the rule itself, the proposed rule, and a cover letter explaining what's going on, saying in essence to the members, dear homeowner, the board is considering adopting the attached rule, and you have to say specific things in that cover letter. It has to explain what the point of the rule is, what goal is it trying to accomplish, what's the purpose of the rule, and what's the effect. What's it going to mean for me, the homeowner, if the board adopts this rule? You have to say all that in the cover letter that goes out for the 28-day comment period with the rule attached to it. We'll talk more in a moment about the significance of that 28-day comment period, but you have to, as a starting point, once you've worked with council to get everything drafted and the board is satisfied with the text of the proposed rule. We have a solar rule, We have the board's input, council's reviewed it, council's drafted it, it lines up with the law, council's confirmed that it lines up with the governing documents, and now we want to send it out to the members. This is the 28-day comment period that we're talking about now. The big exception to this part of the process is rules that are being adopted on an emergency basis. For the board to adopt a rule on an emergency basis, it has to fall under this description here. It has to be intended to address an imminent threat to public health or safety, or an imminent risk of substantial economic loss to the HOA. In other words, we're adopting a rule because of a great big safety concern in the HOA, and we've got to get the word out right now. We can't wait for a 28-day comment period. It's got to go out right now. Or there's something going on in the community where there's going to be a great big impact to property values, to the HOA overall, if we don't get this rule out right away. A few years ago, in the midst of COVID, a popular issue along these lines was pool rules. We were all living under a state shelter-in-place order, various county shelter-in-place orders that affected how much people could be around each other in shared settings. Well, that had a big impact on HOAs with pools. And what are we supposed to do with the pools? Do we let people in the pool? Do we not let people in the pool? And there were actually, at the various authorities that were dealing with COVID, there was a lot of detail, a lot of nitty-gritty into what HOAs could and couldn't do with things like pools. Point being, that was a situation where safety in the HOA was a concern, and it didn't necessarily make sense, particularly in the early days of COVID, to go through a 28-day comment period to set out a rule. You're trying to protect people from safety issues in common facilities, the pool or whatever, and so you need a rule that's quickly put in place to tell everyone what they can and can't do. That's a situation where an emergency rule might be appropriate. The catch is, the rule adopted on an emergency basis is only good for 120 days. If whatever the situation is continues past those 120 days, as was the case with COVID, somewhere in there, you have to go through the process of adopting a long-term rule that's still bound by the 28-day comment period. We're going to talk a little bit more now about the 28-day comment period. So the idea is that you send the proposed rule out to members. They don't get a vote, but they get to voice their opinion. And the board's obligation is to reasonably consider the input of the homeowners. You send it out for 28 days or at least 28 days, and homeowners send an email to you guys, to the managers, saying, well, I don't like this because of such and such. I don't agree with what this has to say. I think it should say this instead of this. Not everything members have to say is going to be worth changing anything over, but the board is obligated to at least consider what members have to say. And we deal with it all the time, where the manager or the board will come back to us and say, homeowner so-and-so said we need to change this. They have some thoughts on this. What do you think about this? And sometimes our response is, yeah, we can't change it the way they want because the law actually specifies what this type of rule needs to say. It's solar, it's elections, it's electric vehicle charging stations. The HOA is limited on what it can and can't say. We have to say very specific things. I understand that homeowners' desires, but we can't just do what they want. Or, yeah, that's a valid opinion. If the board is interested in changing the rule to accommodate what that homeowner is raising, let's do that. And I'll make a little tweak and the board will take a look at it and make sure it's where the board wants it to be. The point is that the 28-day comment period, where you're sending out to members for 28 days and giving them a chance to weigh in, is that the board should work with council, work with management to determine, okay, what are the opinions we actually want to give some thought to? Do we want to change the way this rule looks? Or are we pretty much satisfied with the way it's going to be adopted in that form? That process is also a good sort of temperature taking period. We're trying to gauge, okay, what's the likelihood that a homeowner is going to challenge this rule in court? I made a big deal a little while ago over the idea that you can't adopt rules that go beyond the board's authority. If a homeowner doesn't like what is said in the CC&Rs and the bylaws and challenges it in court, the way the law works, a court will tend to err on the side of deferring to whatever's in the CC&Rs and the bylaws. The idea is those are both contracts that the homeowners have entered into with the HOA. They're binding on everyone. And in some instances, homeowners have actually been able to vote on what's in the CC&Rs or the bylaws. So if I'm a homeowner and I don't like, provision section 2A in my CC&Rs and I challenge it in court, a court will generally err on the side of saying, sorry, Mr. Stewart, you're stuck with that. That's just the way it goes in your community. That isn't true with rules. rules don't go through the same process as CC&Rs and bylaws, the board can essentially do what it wants within reason. So court's not going to be as forgiving of a rule. Of course, can be more inclined to sort of throw a rule out if it goes too far, if a policy goes too far. So this period of 28 days of comments from homeowners is a good opportunity to get a sense of it's already been reviewed by legal. We've given it our blessing. Your council's given it their blessing. But here's a homeowner saying, I don't like this, and I'm really unhappy about it. And I think, I'm going to challenge it in court if it passes. Maybe we want to take a second to consider whatever their argument is and revisit that. And not necessarily we're going to change what we're doing, but maybe it's worth sort of circling the wagons a little bit on their particular issue to at least fend off the likelihood of a legal challenge, because courts are less forgiving of things that overstep with rules or policies. So you send it out for the 28-day comment period, and then the board adopts it in an open meeting after properly considering any comments received from the members. And at that point, it's in place. You've now adopted the rule. You send it out for 28 days. You then have a properly noticed meeting where that's one item on the agenda. The board is going to consider this rule and formally adopt it. You've formally adopted it. A final step that unfortunately gets overlooked a lot of the time is that you then have to tell members what you did. You've told them a rule was going to be adopted. You now have to tell them that it has in fact been adopted. So once the board has actually adopted the rule, they took it up in a meeting. A board member moved to formally adopt the rule. Somebody seconded it. All in favor. Everybody said aye. Okay, so now it's a rule. Within 15 days of that happening, there has to be a general notice sent out to members, meaning it's posted in a prominent designated location in the HOA, or you send it out individually by mail. But you have to provide members with general notice within 15 days that the rule has now been adopted. You have to go through that whole process. The exception to this goes back to emergency rules. If it's an emergency rule, the notice being sent out to members saying it's been adopted has to include the actual text of the rule, the purpose, the effect, and when it will expire. So there's, in effect, a different process for adopting rules on an emergency basis. You don't go through the 28-day comment period. You send a notice out to members saying, here's the rule, here's its point, and we're adopting it now, and it's going to expire on such and such date. Finally, an important thing to understand, I said at the beginning, the CC&Rs and bylaws are very different from rules. A big difference is that rules aren't recorded. Articles of incorporation are submitted to the Secretary of State. CC&Rs are recorded with the county clerk. Bylaws are signed, they're not recorded, and rules don't need to be recorded. They just need to be adopted pursuant to this process and then signed by the board. Okay. So I've alluded a few times to the idea of homeowners saying, once the rule has been adopted, I don't like this rule, I'm going to challenge it one way or another. Now, one thing they could do is actually bring a lawsuit challenging it in court. Another thing they could do, similar to what sometimes happens with a petition for a recall of the board, members can essentially demand a special meeting of the members to throw a rule out if they think it was improper. So Civil Code Section 4365 deals with this. 5% of the members can put together a petition calling for a special meeting of the members to essentially veto a rule change by providing a written petition to the HOA with signatures from at least 5% of the members. If you ever get a petition along those lines, if you get any special meeting petition from 5% or more of the members, let council know right away. There's very specific timing requirements for responding to those petitions whenever they come in, and there's very specific things the HOA has to do in response. Here, that special meeting has to be held within 35 to 90 days of receipt of the petition, meaning, in effect, we've got to get out ballots for, we've got to confirm when the meeting is going to happen, and we've got to get ballots out to the members to determine how they want to vote on this, and all that's going to happen in that time. You can distribute written ballots in lieu of holding a special meeting, but you have to respond promptly to that petition. If members are challenging a rule that's been adopted by the board, the law is very specific about how quickly the HOA has to respond and what it has to do in response. In order for a rule that's been adopted by the board to be reversed by the members, you have to have an affirmative vote, a yay vote, from a majority of a quorum of the members, meaning Whatever a majority of the HOA is, you got 100 homes, 51% is a majority. If only 51 people vote, a majority of those voting determine the outcome of that vote. So a quorum is a little bit more than a quorum is a majority of homeowners in the HOA, of properties within the HOA, and then a majority of that quorum determines the outcome of that vote. Unless the governing documents give you a higher threshold, the governing documents of the CC&Rs, the bylaws say it's got to be approved by whatever, 63% of the members, then that's what actually governs that issue. If the vote is held, then you have to provide general notice to members within 15 days of that vote being held. And if the members vote to reverse that rule, you can't then go back into your next board meeting and readopt it, at least not for a year after that vote. The board can adopt rules on arguably the same subject matter, but it can't be the same rule and it can't have the same effect of the rule that's been thrown out by members. Okay. So once you have a rule in place, whether it's solar, it's an architectural policy, it's election rules, it's rental rules, the teeth of them, the point of them, is that the board gets to enforce them. That's why you have a rule in place in the first place. It's meant to give everyone fair warning about how things are supposed to work, but the crux of the matter is that if a homeowner doesn't comply, the board can then take steps to enforce that rule or enforce that policy against that homeowner. And when that comes up, it's the same procedure as for anything else. There might be an initial notice sent out to that homeowner. Hey, Mr. Smith, you're in violation of of our solar policy. You're in violation of our parking policy. You're in violation of our electric vehicle charging station policy. Please cure the issue, or we'll have to take further steps. And if it's not cured, then the homeowner might be called to a hearing. You have to send out notice of a hearing 10 days in advance. You hold the hearing with the homeowner, and if the board ends up imposing a fine or some other form of discipline, that notice has to go out within 15 days of that hearing. Fines can be imposed for violations of rules if permitted by the governing documents, and the fine schedule should define what constitutes a continuing violation or a recurring violation of the same offense. So what California law envisions is for an HOA to impose fines, which is the major tool the board has to do anything. The board wants anybody in the HOA to comply with the governing documents at all. You really need a fine schedule in place. You need a way of imposing fines against that individual. The way the law is structured, the HOA has to adopt a fine schedule. It has to be part of your annual budget packet, part of the annual policy statement. It has to be sent out to members. If that fine schedule isn't in place, and we have HOAs where unfortunately this is the case, the board effectively is toothless. They can call somebody to a hearing all they like, but they don't actually have anything to do that to that person usually. We can't strip them of their voting rights anymore. That was something that used to be an option to HOAs. Can't do it anymore. You can suspend them from using the common facilities, but the most common best tool for boards to enforce the governing documents is to impose fines. If you don't have a fine schedule in place, $100 for the first offense, $200 for the second offense, or whatever it is, the board effectively can't impose fines. So any accounts that you have where they don't have a fine schedule in place, make sure that they're taking care of that so the board can properly enforce the governing documents the way they need to. And as I said a moment ago, part of what that fine schedule should do is should spell out, okay, we have some violations where it's really just one act at one time on one day, such as a parking violation, or maybe it's something that continues over time. I haven't cut my grass for 3 months. So that's a continuing violation. It's not one violation on one day. It's a continuing violation. Or, I don't park in the wrong spot every day of every week, but I've parked, in the wrong place 5 times in the past 2 weeks. So how does the fine schedule handle recurring violations, the same offense? Those are things that should be addressed in the fine schedule as well. Okay. Some common issues that come up, and we've touched on some of these already. A big one is boards adopting rules that actually wander beyond the authority that they have. They say things about, installing solar that the law doesn't actually allow them to say, or impose architectural restrictions that the CC&Rs actually don't allow them to touch on, or contradict the CC&Rs. Again, that's why you always want to make sure anytime your boards are considering adopting a rule, You encourage them to work with their counsel to get it reviewed to make sure it is actually within the HOA's authority. It's within the board's authority to say the things that rule says. Sometimes it's confusing or ambiguous. A lot of times a board member has a great idea, but once it's actually put pen to paper, it's not clear to everyone else what that board member had in mind. That's another good reason. All these things should be vetted by the entire board, but it's another good reason to get counsel involved to make sure that, okay, here's the goal you're trying to achieve. Here's the thing the board is trying to accomplish. Do the words actually say that? You know, we've got a big concern with how people are painting their homes, and we want to specify that. We have the authority under the CC&Rs, but do the words of this rule actually make sense in a way that a homeowner can be expected to understand? You want to make sure the board has vetted the rule and the council has weighed in to say, okay, I understand what it is you're trying to say. Let's change the words so it actually says what you mean. Unreasonable or overreaching. You know, a lot of times boards are very gung-ho for an issue and want to say things that they actually can't ask of people. Not only do they wander beyond the authority under the CC&Rs and the law, but it's just, they're too onerous. It's too much to ask of people. It's not reasonable. We do see it come up from time to time that a rule has been adopted and nobody really knows that it's been adopted. It's got to be posted properly. There's got to be enough notice to members that it's being adopted. Those are issues that come up, that can come up. Another big one to be aware of is rules being arbitrarily enforced. I have a situation right now where a homeowner is essentially claiming that, you know, you're picking on me with this rule and you're not enforcing it against everyone else. Why is that? Which is right next door to a claim of possible discrimination, right? You know, maybe I'm saying that I feel picked on, the rules only being enforced against me. Well, maybe that's because of, you know, the color of my skin or because of my gender, because of my religion, something along those lines. So you want to be very careful with that. You always want to make sure that your boards are enforcing rules consistently. It's not practical to catch every single violation every time it comes up, but you also can't boards can't use the rules as a way of sticking it to somebody they don't like in the community. An issue comes up, the board is aware of it. They should either enforce the rule or not. They need to make sure they're doing it consistently across the community. Again, some rules are difficult to implement. That goes back to sort of how they're written. We want to make sure they're written in a way that allows them to be enforced in a way that makes sense. Sometimes they're too difficult or expensive to enforce. And again, that goes back to the drafting process. We want to make sure that we've thought through sort of the practical implications of putting this rule in place. And an issue that could come up, I made reference to this a moment ago. If a rule is set up that effectively interferes with disability rights or special accommodation rights, you could actually be looking at a much more serious claim against the HOA. We're talking now about federal fair housing claims. Anytime you have a situation involving a possible disability or claim of discrimination, you want to get counsel involved right away because those claims can get very big very quickly. But a possible avenue to those claims is if you've got a rule that is otherwise fine, but doesn't anticipate issues that might come up when it comes to folks' disability, or doesn't include the right sort of carve-outs for disability issues or special accommodation issues. Okay, you've heard me say variations of these things throughout the presentation. Obviously, we emphasize getting counsel involved really from the beginning of the process. Sometimes it can be a time suck to have boards draft a rule that council then has to effectively rewrite. It can be useful to have boards start drafting them so we know what it is they're aiming for, but it's good to have council involved from the beginning. You want to determine with council whether the rules will address the board's concerns or homeowners' concerns. Sometimes a rule is being considered by the board because homeowners are complaining about a particular issue. You know, these 3 homes over here are constantly leaving trash out in the streets. We don't really have a policy that addresses that. Can we, homeowners complaining constantly, can we put together a rule that addresses that? You want to work with council to draft new rules or amend existing rules. We want to make sure that they're consistent with the governing documents and applicable law. We'll advise you regarding the procedural requirements for implementing those rules. Prepare a cover letter for the proposed change. I talked about that earlier. Anytime you get a member challenge, you want counsel involved to help the board navigate that situation. And when you have violations that come up, in situations that are a little difficult or contentious or sensitive, you really want to get counsel involved there as well. Sometimes having the hearing notice worded just so can make a big difference in whether or not the homeowner receiving that hearing notice goes off and hires a lawyer, and that lawyer thinks the HOA is or is not in a good position to be challenged. And you want counsel generally involved for particularly difficult hearings, or if you're looking at internal dispute resolution processes or alternative dispute resolution processes. Okay, so quick overview, everything we just talked about. Rules are more susceptible to challenge because they don't go through a membership vote. You want to have them well crafted before they're adopted. You want to make sure that the rules are adopted in strict adherence to what the law requires for that process. You want to make sure that they're relied on consistently to be enforced among the homeowners. And anytime you get any kind of a challenge from a homeowner, you want to make sure that the council knows about it right away. I may have breezed through that a little too quickly. Do we have questions, comments, concerns? What do you guys want to talk about? I hear, oh, yes, Nicole.
has her hand up.
Go ahead, Nicole. I think you might be muted, Nicole.
Thank you. Oh, yeah, I unmuted myself. Thank you. No, I just had a question since I've had this come up this afternoon, actually, where
Okay.
I have a homeowner saying that we're harassing her by sending her violation notices. Now we're calling her to a hearing. And one of the items that are in our notices is that if you would like to respond to the board, you need to do it in writing and or attend your hearing. And so, she's claiming that we're harassing her, we're targeting her.
Just by sending the notices out?
Just by sending a letter. And she's claiming that she has all these disabilities.
Okay.
And that might be true, but what would be the less aggressive, I guess, the less aggressive way to ask her, please just either draft a letter or correspondence that you'd like to have to go to the board or attend the meeting, to de-escalate that situation? Or should I let the board know that she's threatening? I mean, I can play them the voicemail in the executive session.
Real quick, and I don't want to go too far down this road, but what's the violation and what is she saying her disability is?
It's items stored in the common area.
Okay.
So this property is going through a $2 million siding project. And her building is one of those that are being addressed first because they're mostly deteriorated. And part of them being able to finish that project and paint, there's a rule that they cannot store items in the common area, and anything stored in their back patio must be away from the walls and not touch anything.
Sure. Sure.
And so they're coming to the completion of that building, and we've sent out notices. We've sent out, reminders. First, we start out with courtesies calls, and then we sent out violation notices, and then we've gradually sent out hearing notices. And she's never once responded in writing, and I've asked her to, and I've had conversations with her explaining the process, and she's saying that, well, she's old and she has all these ailments, and she feels like she's being discriminated against and we're harassing her.
Okay. Has she said at all what her ailments are or her disability is?
She said something about a bladder infection and kidneys and things of that nature.
Okay. I think you're in decent shape, but I would let the board know that she's making these threats now, and I would get counsel involved. Is it one of ours?
Yes.
Okay. I would email me or Ann or Colin, whoever. Let's get us involved right away, just because she's raising disability. Okay. We want to make sure. I suspect, based on what you're telling me, that there isn't really an issue between what's being asked of her and the disability. But we have to be very careful with what gets said to her. Okay.
Okay.
And to the extent she might be asking for an accommodation, which it sounds like she's not exactly asking for an accommodation, but we want to make sure we're addressing that possibility. To your sort of overall point, you're absolutely right. It happens all the time that homeowners say, you're harassing me because you're enforcing the governing documents. Well, no, that's what the HOA is supposed to do. And the process you just described is exactly right. We sent you a notice that this needs to happen. We sent you a notice when you didn't do it, and we called you to a hearing to address the issue. That's what the HOA is supposed to do. You should work with the board to make sure, okay, guys, are we being consistent with this issue? But it sounds like you are. It sounds like you sent exactly the same notices to everybody. That's great. That's what should happen. So I think objectively, there isn't an issue with the HOA doing that. You just want the work to be able to proceed. And sometimes a hearing can be a useful tool for sitting down with the homeowner and saying, what's the deal? What do we need to do to fix this? Not necessarily throwing a fine at them, but just having that conversation. Here's our concern. Here's your position. What can we do to fix this situation? So I think objectively, the HOA is in good shape. You've done a good job by them. You just want to get us involved. Shoot me or Ann or Colin an email so we can get involved and make sure the HOA is able to address the issue while not getting in touch with the disability issue. That help?
Thank you. Absolutely.
Absolutely. Great.
And just to add a little bit onto that too, Nicole, this is an owner too who hasn't paid their special assessment. And so if they're making allegations or claims regarding moving their stuff for the repairs to happen that, cause the special assessment, that might be something that the attorney should also be aware of and assist the board with.
Sure. That might be useful. Great question, Nicole. Thank you very much. Other questions? I see Cheska has a hand raised. Yes, Cheska.
Hi, I just have a quick question. Just correct me if my understanding is right. For every rule adoption or any rule that's amended, it would go through a separate set of the 28 comment day period, right? So for example, they amended the parking rules, and then when 28 comment day period passed by, they went to a board meeting. They figured out that there was something that they needed to amend again in the parking rules. So they amended it, and then now it's going to go through another 28 days, right?
Great question. Yeah, the short answer is yes, but it's something that causes a lot of confusion. Where people, and we get this question a lot, do we send it out again? We just sent it out 2 times already. Do we need to send it out again? What I'll say is this: if it's a relatively superficial editorial change, we realize there's a typo in there and we're fixing the typo, no, it doesn't need to go out for a comment period again. But if something is being changed in the text of it, from what members have already seen, yeah, best to err on the side of doing another comment period and maybe saying in the cover letter, this is the same thing you already saw, here's the thing we actually changed, let us know if you care. But just cover the board's bases on that front. Absolutely.
Sounds good. Thank you.
Absolutely. Good question. Anyone else? Any other questions? Anyone dealing with any difficult issues right now in terms of rule adoption or rule enforcement?
I want to share. I am. For the same reason, we're just having some challenges with this particular community because the previous management, I guess they got away with a lot before, which wasn't really consistent with their rules nor their CCNRs. And now that, we're adopting new rules, there seems to be some pushback saying kind of like, how come this was allowed before? How come before
Right.
I didn't have to submit, follow these types of rules or submit this kind of documentation? Or like, why do I need to make a separate request again? This was approved, 2 years ago, we were doing this and it was fine, kind of thing. But it's just more of them ranting, I guess.
Yeah, no, and that's a common problem. It comes up a lot. I've got one right now I can think of where, we haven't been enforcing the governing documents properly for all this time. Now we're trying to do it and people are mad at us, right?
Yes.
Yeah.
Yeah.
Yes.
Yeah. And so what sometimes can be useful in that situation is to, and actually I just thought of another one where we're doing this, is to give members some warning. In consultation with council, working with our management, the board has come to realize that the governing documents require us to do X and Y and Z. We know historically we haven't done that. So this is fair warning. Everybody understand it's our view that we have to enforce the governing documents in this way. And going forward, we intend to do so. Maybe a letter out to the members, and we do this all the time, saying essentially that. The governing documents require this. We realize historically we haven't quite done that. We haven't quite held everybody to that, but we have to. And so we're going to do so. And here's, 30, 60-day warning. Please make sure you're not doing this. Please make sure you are doing this properly, because after that, we're going to be holding everybody accountable. You give everybody some fair warning. And what it does is it helps protect the HOA from a claim that the rules are being arbitrarily or capriciously enforced. Can everyone still hear me? I'm getting a weird message that I might be.
You're breaking out a
still here?
little.
Okay.
Yes, you're just breaking out a little.
Okay. It's better now?
Yes,
Okay. Thank you very much, Veronica.
you're welcome.
The danger is that somebody comes along and says, well, the reason you enforced it against me and not against somebody 2 months ago before you realized what was right under the governing documents isn't about you enforcing the governing documents. It's because you're discriminating against me. You don't like my race, my gender, my sexual orientation, whatever. Or just generally alleging that the board is inconsistently enforcing the governing documents. That can be a claim against the HOA. The risk of going from not enforcing them properly to enforcing them properly is that somebody makes that claim. The board's being arbitrary, it's being capricious, it's being discriminatory. So sending out that letter to the members saying, guys, we realize we haven't always done this, we're doing it now, giving them fair warning helps to sort of mute that risk of a claim that the board is being arbitrary or capricious or discriminatory. So that can be a useful tool when you're trying to address that dynamic. I hope that helps. Any other questions, comments, concerns, things you guys are struggling with? Okay. And I will send the PDF over to Melanie so she can circulate among all you guys. Thanks so much for coming. If you think of anything else, feel free to shoot me an email. Nicole, please do email me or Ann or Colin about the thing we talked about so we can get on that. And otherwise, thanks very much, guys. Always a pleasure to see you, and we'll be talking to you again soon.
Thanks so much for your time,
Thanks,
Lance.
Lance.
Thanks, Veronica. See you guys soon.
Thank you, Lance.
Thanks, everyone.